we okay? Go?
Yes, yeah.
Want to raise? Application in the matter of the Pallier and the Pallier.
Yes, Mr. Turner. I can, as you know, I think we sent you a message. We'd like to hear you first. We've read the skeleton arguments carefully. We've had a chance to discuss the case amongst ourselves. At the moment, we don't think that you need permission to appeal. It seems to us that what you're doing is seeking to uphold the judge's order on different grounds, so it's properly the subject matter of your respondent's notice. There's no part of the order, as I understand it, that you quarrel with. The judge dismissed the appellant's
That's right. The judgment we quarrel with parts, but not the order
the appeals
itself.
are appeals against orders, not judgments, and there's no part of the order, as I understand it, that you quarrel with. We have considered the original order made by the district judge. Our provisional view is that it was a perfectly valid order. It just didn't do what the appellant wanted it to do. Right. It registered the French order, which covered both parental responsibility and maintenance obligations. The application was made to the right court under the right regulation for the purpose of registering the order insofar as it concerned parental responsibility. And that's what the district judge was asked to do, and that's what she did. That has the consequence that all the argument about whether the order is void or voidable falls away, because it was neither, it was perfectly valid. The question then is, what is the reach of the power of variation in the family procedure rules? And that, as we see it at the moment, is the short point on your respondent's notice, and everything else falls away. So perhaps you could just address that point. And I should also say that we would like to hear Mrs. Bailey-Harris on that point before we move on, if we need to the appeal.
Well, Lord, certainly. I should formally introduce us. Miss Dunseith and I represent the respondent. Can I call him husband,
Yes.
although long since former husband? And Miss Bailey-Harris and Miss Amouche represent the appellant, who I'll call the wife, if I may. And I'm sorry I'm croaking today. I don't know why. I haven't got a sore throat or anything. I've just acquired a croak. It was Miss Dunseith and Miss Amouche who represented the parties in the proceedings below. I think Miss Bailey-Harris has also had some involvement on behalf of the wife in the past, but I'm, as it were, the new boy, and I came into the matter for the first time after permission to appeal had been granted to the wife.
Yeah.
I only say that because you may have seen reference in some of the documentation to leading counsel for the husband in the past. That wasn't me. That was someone else entirely. Your lordships, my lady, know the two issues in the case. The judge, as you know, declined to make the order that was sought, seemingly on the basis that the requisite conditions for the making of a rectified order hadn't been satisfied. Satisfied as at the 28th of September 2017, or indeed subsequently, insofar as subsequently was relevant, although our case is...
The French order records the husband as living in Italy. The application for registration records him as living in Paris. His subsequent evidence seems to suggest he lives in Hungary. So the question was, were there assets within jurisdictions.
certainly
and-
read the papers.
And the judge was not satisfied that there was sufficient material on which to draw the inference that there were assets.
As I say, either in 2017 or later, although we say later is a complete irrelevance.
We understand that.
Yeah. Lord, the respondent's notice, can I just address in a little more detail what that's intended to cover? Because it's intended to cover, first of all, the anterior jurisdictional issue, and within that, it is intended to cover also not just the question of was the judge right to find that the conditions, precedent, as it were, if I can call them that, hadn't been met, but also was the judge right when deciding that or should the judge, when deciding that jurisdiction existed, have taken into account rather more matters than she did. And in particular, we bear in mind what's been said in various of the authorities by Sir James Mumby and by Baroness Hale in various of the authorities, that the jurisdiction, whatever its extent may be under Rule 4.1(6), is not unbounded.
Yes.
It doesn't create a free for all.
Yes.
And we say that on a proper consideration of that jurisdiction, whatever it may have been, it didn't cover the gravity of the alleged errors in this case, which I'll come to, because I will emphasise what I say were the egregious faults.
Well, I mean, here we have an application for Order A under legal regime A, which the district judge was asked to make, and that's what she did.
She made, yep.
And now it's proposed that that order be substituted by Order B,
completely different
under
form
a different
order.
legal regime, and not only that, that it has retrospective effect.
Yeah, and it's not just a different order, but it's a different form of order, because the order that it said the wife really sought was a declaration of enforceability, whereas what she actually applied for and what she got was recognition and registration under a completely different piece of legislation, because the international instruments are legislative instruments for our purposes, and she did it by a completely different process. It was done by way of Part 34 of the Family Proceedings Rules, as opposed to, sorry, it was done under Part 31,
as opposed to Part 34.
whereas it should have been done under Part 34. So it's not just a variation, and it would be to mischaracterise what was sought to describe it as a variation. It's a complete rewriting. It's a complete substitution of a different order under.
It's in two different courts. The parental responsibility was properly issued in the High Court and dealt with in the High Court, whereas the maintenance regulation is family court.
Yes. Lady, as I say...
I think we understand.
You understand that there are...
That's why I say it's quite a short point at bottom.
Yes. It's quite a short point, but it's caused trouble over the years. And there are lots and lots of authorities on it.
Well, I don't think we need to plough through lots and lots of authorities.
No, well, I'm hoping not to, although I may have to take the court to a few of the authorities to try to show where the misunderstanding has arisen. Because nobody has ever actually analysed the argument. People have touched on it in various of the authorities, but no one's ever analysed it in detail. It's there in the textbooks as well. It was in Jackson's Matrimonial Finance. I think Mr. Nagpal was the author of that particular part of it. But however it's to be construed, it's certainly, we submit, never been construed as broadly as the way in which the friends seek to have it construed in this case, and in which the judge below was persuaded it could be construed. A complete rewriting under totally different legislation. And one can't even, if and insofar as the Tibble's criteria of things like mistake were relevant, say there was a mistake on the part of the judge. Your Lordship's comments are right, the judge wasn't mistaken. She did exactly what she was asked to do on the material that was produced for that purpose and which satisfied that purpose. There was no other material in front of us, certainly not material that would have enabled her to go on to consider the criteria, the habitual residence.
There was nothing in the application for registration, at any rate that we have seen, that deals with the husband's assets within the jurisdiction.
No.
And the only information in the form was that he lived in Paris.
Lord, a slight qualification to that, because the application would have included the original French order in translation, which did have some information about the husband's assets as at 2010. So to that extent, there was a little information about the husband's assets, and there was a sum of money held in escrow on behalf of, to be held for the wife, which the judge dealt with in her judgment. But other than that, nothing about the husband's residence, let alone habitual residence, other than, as your lordship pointed out already, such information as there was all addresses overseas.
And no reference to the rented property in London.
And no reference to the rental property in London. If and insofar as that even existed in 2017, because I do emphasise that what the judge has to do, if she is going to rectify the order, is to put herself in the position of District Judge Aitkens back in September 2017. The wife can't seek an advantage out of her failures and say, oh, because I failed to do what I intended to do, or my lawyers failed to do what they should have done, I can then not only rectify it, but rectify it taking account of material that's only come into existence now. Of course, we don't accept that inferences, as are asserted, could be drawn from that anyway, but we say that's all irrelevant because that material wasn't before the court in 2017. So the judge couldn't have made the order on that basis.
I mean, do you say that, I just want to be clear how far your submissions go. I mean, 4.16 in terms talks about the court having power to vary or revoke an order. Well, it doesn't, in fact, use the word rectify.
Quite, that's one of my points.
So, to get to the position that you're assuming the court has jurisdiction to rectify requires you, in fact, to interpret vary or revoke as including a power in the strict sense of rectification, which is to replace the order as drawn with the order which the judge, in fact, made.
Yep.
And would you need it anyway? Because rectification is really a form of putting right what they wanted. So that can be dealt with under the slip rule.
Yes.
And there is a slip rule in the family
We
procedure.
know the slip rule is rather narrower than people often think the slip rule is, but there's the equitable doctrine of rectification that still exists. I mean,
But that's not for second thoughts.
No. I mean, that was considered, and I can tell the court what was said. There's a House of Lords, a Supreme Court case called Marley and Rawlings, where it was held that the circumstances that give rise to a classic claim for rectification, where there can be no doubt what was actually intended by the person who made the relevant instrument. Now,
Well, rectification does not correct what people wanted to do, it corrects the way they expressed what they meant.
Quite. And it's the person who made the document.
Yeah.
And this document was District Judge Aitkens. I keep adding an S to her name. There isn't an S. It's Aitkens, although...
She did what she meant to do.
She did what she meant to do.
That's what she was asked.
And she did what she was asked to do.
Yeah.
There was nothing to give rise to classic rectification in the sense that it's been known since time immemorial and confirmed by the Supreme Court in that authority. Whereas the word rectification is known to those who drafted the family procedure rules because it appears in 4.7. And we've referred to that in one of our skeleton arguments. I should say in passing that we do rely upon the content of both of our skeleton arguments. Indeed, your lordship's foreshadowed me because I wasn't going to address questions of invalidity or not, because it seemed to me exactly as your lordship said, the order wasn't void at the outset. It did exactly what it was intended to do. So difficult to see how, on reflection, questions of validity actually arise. So I'd, in any event, abandon that part of our argument.
That makes things shorter.
Yep. Let me just analyse for a moment what the wife was asking the judge to do. She was seeking to have that order of September 2017 turned into what we say was an order of a different nature, in respect of which she'd made no application, which would be made under completely different legislation, in a significantly different form, by a different process, and subject to conditions, none of which were considered by the district.
And by a different court.
And by a different court.
Yeah. Now, we've got all that, Mr. Turner.
The trial judge considered that the power to do those things, rectify, we say, rewrite, substitute, existed under Rule 4.16, and we'll have a look in a moment at exactly what that rule says, analyse the wording of it. I don't need to take the court to the underlying material, the mother's application, although I do highlight the fact that the mother's application at D10 is an application for registration of, etc., under what I call Brussels II revised. And that word under is perhaps significant when you're looking to see under what power the order was made. And indeed...
Are you still going to trying to pursue that this wasn't made under the rules?
I am indeed, my lady. And indeed, I suggest that all of the authorities, including one of your ladyships, proceed on an incorrect basis. And all of those decisions were actually justified by a different route. And in any event, none of them are remotely similar to this, because in all those cases, the form of relief that was being sought was the same, the legislation was the same, what was being corrected was something of greater or lesser importance within an order that had been made, sometimes because of error, sometimes because of change of events. So the change of events, children cases, I confess I don't understand the lengthy judgment of Mr. Justice MacDonald in the inherent jurisdiction case, because that's entirely justifiable under straightforward fresh application on change of circumstances, welfare of the child. What Lady Hale said in the Rael case, one doesn't need to go down the route of 4.1(6). Not that his lordship did vary it anyway, but all that he had to do was treat it as an application to vary an order, justified by a change, an asserted change of circumstances of the child, and then make the order on that basis. And that
But even if the judge did, as he did, discharge the return order, it doesn't mean the return order never existed.
No. And in fact, interestingly
in theory,
as well...
I suppose the mother was in breach of the order until such time as it was revoked.
Yes. He could have discharged it on the basis of a change in circumstance on the welfare consideration under the Children Act. No problem with that. Just as, interestingly, the two main categories of cases where it seems to have been referred to, even though most of them don't result in an order being changed, are the setting aside of financial orders, which don't, I submit, actually justify 4.16, and the case of Sharland and Gohill don't actually say that. I was in Gohill, and I was the one who raised this whole point in Gohill. And we were deploying Mr. Nagpal's argument there as well from Jackson, although we didn't need to, because everyone conceded in Gohill and Sharland that there was jurisdiction anyway for a first instance judge to reconsider it, even if by an action on the case. And that's why, as you'll see, it didn't actually turn on 4.16, and by the time the matter was dealt with in the Supreme Court never said 4.16 is the justification. There were other justifications, and of course there was a new rule which had been created as well
Well, just hold on a minute. I thought you were going to tell us why you say the order was made under the regulation
I am.
and not the FPR. Well, shall we deal with that point
Yes,
first?
certainly.
And then you can address us about
Certainly.
the scope of 4.16.
May I just remind your Lordship, in case I forget later on, that two of the areas where problems have been created are the Hague Convention situation, where an order for return has been made in this country for return elsewhere, and question of, is there power to set that aside and reconsider it? There's a specific rule now that deals with that, Rule 12.52a. The financial problem, the setting aside that, there's a specific rule to deal with that, Rule 9.9a. Of course, those rules do actually contain a substantive power, and that's where I'm going to go to in a moment on 4.16. They're rules made within the family procedure rules, but they do contain something rather more than a mere case management power, because it's not my submission that 4.16 only covers case management orders. My argument is that it only covers orders which have been made under the rules, whether those orders be characterized as case management, whether they be characterized as procedural, or whether they be characterized as substantive orders. And what else does Rule 4.1(6) mean? What's the reason for the words under these rules? Because if you didn't have those words, you could do all of the things that people are arguing you could do. You wouldn't need 9.9a, you wouldn't need 12.52a, you wouldn't need the legislation under which Section 31F6 of the Matrimonial and Family Proceedings Act, which now has a specific power to replace orders with effect from the time they were replaced. You wouldn't need all of those. So if we...
I mean, the real purpose of, I would have thought, was of 4.16, just like the CPR equivalent, which is, I can't remember now, 1.3, is it?
3.17, I think.
Yes, whatever, it's probably changed now. But the reason you put a rule in that expressly gives that the court's power to make an order includes power to vary or revoke the order is to obviate the need for an appeal. Because if you don't have that power, then the only way the order can be set aside is by one of the parties appealing the order. That's and a lot, as you're aware, a lot of the authority in the CPR context has had to consider the question of when you can use the CPR power to amend the order, revoke the order, or whether you've got to go to the Court of Appeal to get the order varied or set aside. I mean, that's the primary problem that the rule is addressing.
Indeed, I've printed out, and I've got copies that would be helpful, an authority of your Lordship's own sitting at first instance, where
sparked any number of cases.
It's referred to in some of our cases. It's a case called Lloyd's Investment (Scandinavia) Limited against Christian Ager Hansen. And that was a case where an order had been made under the CPR for an asset freezing, and an application was made to your Lordship, in effect, to vary or set aside that that order. And I'm looking at paragraph 7 of your Lordship's judgment in that. Your Lordship said, in relation to the original order, the Deputy Judge exercised a discretion under CPR Part 13.3, so the original order had been made under the rules, not under any other jurisdiction. It's not open to me as a judge exercising a parallel jurisdiction in the same division of the High Court to entertain what would in effect be an appeal from that order. But your Lordship went on to say that you did have jurisdiction under Rule 3.1(7), which enables the court, said your Lordship, to vary or revoke an order. This is not confined to purely procedural orders, and indeed the order that had been made, the asset freezing order, couldn't be described as a purely procedural order, but it had been made under the rules. And your lordship then went on to consider whether part 3.17 should be applied on the facts and dismiss the application on the facts.
Yes, but I mean, we don't need to go down that road. But I mean, the Court of Appeal has considered this point, I think, at least twice since I made that decision. But the real issue, though, is whether what the circumstances are, and whether, for example, there has to be a change of circumstances or something of that kind to justify exercising the power. But I think my original point stands that whatever may be the conditions for its exercise, the real purpose of this power is to enable the court that made the order to vary its own order without the necessity for an appeal.
Yes, although sometimes, of course, that was the use of the rule in situations such as setting aside substantive financial ancillary relief orders, because it's often the situation that where what's alleged is material non-disclosure, you've got to have a factual investigation. It's not an appeal on a point of law, and everyone agrees.
Mr. Turner, we're getting into the scope of the power of variation, and you were going to tell us why you say the order was not made under the FPR, but it was made under the regulation.
Yes.
So can you deal with that now, please?
Well, can I take the court to Rule 4, please? It's in the bundle of authorities, and we'll find it at in tab 44, at printed page 821 and 822.
Sorry, which bundle did you say?
It's tab 44 in the authorities bundle.
Yeah, but which of the authorities bundles?
Oh, I'm sorry, it's I'm using
second.
the electronic version. It's the second.
Yeah. Okay.
The first thing to note is the heading. And again, I make absolutely clear that I don't suggest that the ambit of the rule is confined to what might be described as procedural matters, just as in the CPR, if there is power under the CPR to make a substantive order, such as a striking out or a summary judgment or whatever it is, which are clearly powers which are conferred by the relevant rule, then Rule 4.16 in the FPR or the Rule 3.17 in the CPR are engaged. But Part 4 generally is headed General Case Management Powers. If you look at the 5 sub-rules which precede paragraph 6, I suppose applying an a justem generis type of rule, one can see the nature of that which is within Rule 4.1. And then we have Rule 4.6 itself. A power of the court under these rules, so the word power, first of all, needs to be emphasized, to make an order, includes a power to vary or revoke the order. And my first point is, of course, this is not an obligatory rule. It's a discretionary rule. The court can, albeit exercising its discretion in a principled way, the court can decide to either grant an application of this sort or not grant an application of this sort. So no obligation, first of all. But it refers to a power to make an order. So first of all, it's premised on the original order that one is seeking to vary or revoke, having been made by a power, and the power has to be under these rules. The rules themselves, whether one looks at Rule 31, which is the rule relating to applications for recognition of children, or whether one looks at Rule 34, and if necessary we can turn them up and look at them, they don't confer any power at all. What they do, each of them, in their various different ways for their various different purposes, is to set out a procedure that is to be followed.
Right. So if a court were to make a property adjustment order, your argument would be, well, that's not a power under the rules, it's a power under the Matrimonial Causes Act.
Quite.
That's a very narrow reading of the rule, isn't it?
Well, I say it's a natural and grammatical reading of the rule, because otherwise one comes to the question, well, where does it end? Does it mean that on an order making arrangements for children or matrimonial finance or property order, you can replace it with an order for possession under the landlord and tenant legislation?
Well,
what are the...
Well, that would go to judicial exercise of discretion, not the source of the power. I mean, the source of the power is always going to be traceable back to a statute.
Yeah, I appreciate, and the authorities say, as we have said, that there's sometimes a failure to distinguish between whether one is exercising the power or exercising the discretion within the power. But my primary point under this is those words, under these rules.
Yeah.
What's the necessity for them? If you remove them, a power to make an order includes a power to vary or revoke the order. If you're trying to change a matrimonial finance order into something totally and utterly different, the court will exercise its discretion not to do it. So why do you need the under these rules? Because I submit it's not intended by the draftsman that this is a power to interfere with substantive orders that have been made under substantive legislation, such as the Matrimonial Causes Act, although I do hasten to say that, of course, there are various parts of matrimonial causes law where the power is contained within the rules. The making of decrees nisi absolute, those sort of things are contained within the rules, because they're, as it were, the quasi-procedural aspects of it, but they're contained within the rules. So one could justifiably rely on this rule to vary or revoke an order of that sort. But what the draftsman was not seeking to do was to give power, and indeed the question is who exercises this power? Is to be a district judge varying and revoking an order that's been made by a substantive order by a High Court judge? Or does one ask, well, unless there is a specific rule about it within the rules,
Yeah.
does any challenge to a substantive order have to go by another route?
Yeah. So your point, as I understand it, is that the phrase under these rules does not give the court a power to interfere with a substantive exercise of power derived from a statutory source.
Yes, and by statutory source I include
Regulation.
instruments, regulations that have the effect of statute because they're enforceable in England under the European Communities Act.
Yes.
Directly.
Right. Okay, well, that's the proposition.
So that's the proposition. And I say that those words under these rules have to have a meaning. And how can one read them to mean something else? And why should one read them to mean something else? Because if there is to be an interference with a substantive order made under a substantive power that's conferred elsewhere, then the remedy for that should be found elsewhere.
Yeah.
Or
And you say that FPR 31 and or 34 only prescribe how you get to the exercise of the substantive power. The substantive power still derives from the regulation. It doesn't derive from the rules.
that's exactly what we're saying.
All right, we've got that.
Yeah, but I do emphasise again that there are some rules that go beyond and significantly beyond being merely procedural
I
or
understand
merely
that too. All right.
case managerial.
Next point.
The remedy in this case, the proper remedy, I say, for the wife would have been just to make a fresh application. There was nothing at the time to stop her making a fresh application, and indeed the judge below made that point in two places. First of all, in her judgment, if we look at D8, we can see in the latter part of paragraph 21, as the judge was using it as a justification, as it were, for not accepting the argument that she should refuse. She was saying, oh, well, what's the point? She'll just make a fresh application. Well, of course, the difference is, and the reason why the mother apparently hadn't made a fresh application at that time was the judge herself recognised the incident of costs in the meantime.
Yes.
Well, that's the problem. If you do things wrong, there may be consequences. And the judge also, when she did eventually refuse the application, but on a different basis, at paragraph 40, she said, satisfied the wife's entitled to apply for registration, declaration of enforceability. Whether she'll succeed depends on her ability to satisfy the court, the husband's habitually resident. So there we are back in November. Rather than pursuing this appeal, the mother...
7 weeks left.
Yep, well, she could have just, as long as she'd issued an application.
Understood. And
so she had plenty of time after this whole thing was raised to say, oops, solicitors, what are you going to do about it? If you've got me into this mess, you can compensate me for it. But you can't just rewrite an order like that. Even if there is a power, it's not a power to make completely different orders under completely different jurisdiction, etc., etc.
Yeah. Well, that goes to the scope of the power. You've said what you want to say. You've said what you want to say about under these rules, have you?
I've said what I want to say about under these rules, as opposed to looking at the authority. But that is the answer to what one should do about it. There are other situations where one might say, oh, well, it would be very convenient to have a rule. And the courts have said that in various places. It would be very convenient to have this general rule. But convenience isn't enough. Indeed, the Rules Committee have appreciated that by once a lacuna, and a genuine lacuna has been thrown up, creating a rule to cover it, such as 9.9a, such as 12.52, such as the new power that was inserted in the 1984 Act, which allowed one to, as it were, to rewrite. So it's not a power to revoke any order that's been made. And indeed, as Sir James Mumby and Baroness Hale have said, the order, whatever it means, the rule, whatever it means, is not unbounded.
Yeah.
So where are the boundaries, we ask?
So now we're going on to the limits.
This is moving on to the limits.
FPR 4.16, yes. Right?
But my primary point is the one that I've just addressed.
Right, all right, well, we've got that point.
I suppose there's an additional point under that. Varying the order doesn't entitle you to vary the application.
Right.
Can you vary an order even under Rule 4.16? An order which was made, in fact, under the Brussels II revised regulation and under the process set out in Rule 31. Can you vary that?
Your progressive argument seems to me to be, one, you say there's no power.
That's right.
Two, in any event, this wasn't an application to vary or revoke.
Yes.
And three, even if there was a power, and even if you were trying to squeeze it in, vary or revoke,
it was
it's
beyond
not
the boundaries.
Unbounded and it's beyond the boundaries.
Yes. Quite apart from the question of the conditions precedent, as it were, because that's a separate matter.
That's completely separate. We've put that in a box for the moment.
Yeah, right. So.
All right, well, let's move on then to the limits of FPR 4.16.
Yes. Can I take yours first of all to what Baroness Hale said in Ray L, because that seems to be the highest authority case where this was touched upon. My submission will be whatever is said about Rule 4.16 and its ambit. This question that I posed has never actually been answered. It's never been explained what the meaning of the words "under these rules" is intended. Are we going
back to under these rules?
Sorry,
are we going back to under these rules?
This is all part and parcel of under these rules and what it actually means.
I think, I mean, without wishing to extend this part of your argument, because I think...
Sorry, my Lord.
I say without wishing to go back over old ground, as my Lord said, we need to move on. But I think the point you're putting is accepted in the White Book as being the correct interpretation of the same phrase under CPR 3.1, because if you look at 3.1.17.4, which is page 119 of the White Book, I've just been looking at, under the heading Other Limitations on Rule 3.17. They make the same point. And Miss Justice Hart said under these rules didn't, for example, include under the old RSC, but then more to the point, in the next paragraph, they say that an order that was made for periodical payments under the Damages Act wouldn't be an order that was made under these rules, for purposes of the rules, which I think is the same sort of point that, they don't give any authority for that, but that's certainly the editors of the White Book seem to take that view.
Well, my submission is the only authorities are ones where what is said is either obiter, or the rule hasn't been applied in the event, or if one looks carefully at the authority on which it's founded, one finds that although Rule 4.16 was touched on in passing, there was another justification, and or it's a special situation, such as the children's situation or the matrimonial finance situation, where there is no other effective remedy. Such with children, you need to get on quickly. With finance, it's often, if it's a material non-disclosure case, you need a first instance consideration of it, and it's a bit long-winded to go up to the Court of Appeal and get the Court of Appeal to refer it back down to the High Court, which was another route that was available. But here, it may be inconvenient to the wife, but there is another route, or was another route, that was open to her for ages, and that was to make a fresh application, and indeed to satisfy the conditions precedent on whatever information she was able to produce at the time.
Yeah.
And she could approach the central authority to assist in getting information.
Where do we find Re L?
It's tab 16, which is within the first bundle.
Yeah, in which part?
And this was a case when I'm sorry, I apologise for the fact that the authorities, many of them, don't comply with the rule about citation of authorities. It drives me absolutely crackers when they don't, because one doesn't have the headlines.
Or sidelining.
I know. I mean, I'd carefully sent my list of authorities with the hierarchy of citations as required,
anyway,
and then they turn up.
We've got it in a transcript, or at least the printed version as handed down. We haven't got it in the law report, but we can find it in the law report.
It's so much better The actual law report is shown on the index to the authorities.
Yes.
That's
But
the
anyway, we know what
curious
this
thing.
case is about. It's about judges reopening their judgments before a final order is drawn up.
Yes.
So which paragraph do you want us?
Well, one needs to bear in mind what the case was all about. And what had happened, it was a care case, public law care case, where there'd been the split process that's often adopted, with a fact-finding taking place first of all, followed then, if the threshold is satisfied, by a substantive welfare disposal. And at the end of the fact-finding, the judge had found certain facts which put the blame for injuries on one party.
Yeah, and then she changed her mind.
And then she changed her mind.
We know that.
Absolutely. And the question was, what could be done about it? Did you need Rule 4.16 to do something about it? And I say the answer is that you don't need Rule 4.16. Baroness Hale's judgment in the case. Can I take you to well, she starts off by pointing out that the order hadn't been sealed, so there's long-standing common law authority that enables one to reconsider in any event. So that was an answer to the actual case. But her ladyship went on to deal with the hypothetical situation. What if the order had been sealed?
Yeah, we're looking at paragraph 37, aren't we?
Starting with 32, in fact.
32, all right.
Under the heading, what if the order had been sealed?
Yes.
On the particular facts of this case, that's all that needs to be said. That's the one can do it in that way. But then at the end of paragraph 33, her ladyship points out that a split hearing is merely part of the whole process of trying the case. The case is part heard at the end of the split hearing. So whatever order a judge may choose to make, it's not the concluded order. And on that basis, we look at the end of paragraph 35 on page 339. You've got to bear in mind the paramount consideration of the child's welfare. Much of the evidence will be relevant to both parts of the inquiry, may be helpful to separate out some issues for early determination that do not always neatly coincide with the legal issues in the case. And then at the end of that paragraph, it would be detrimental to the interests of all concerned, but particularly to children, if the only way to correct such an error were by appeal. So we have the pragmatic, let's look for an answer to it. But the answer, I submit, is that since it's part and parcel of one hearing, even though there may be an order with recitals, it's a case management order, effectively, until the final order at the end of the welfare stage of the case. And at paragraph 37, her ladyship said both the civil procedurals and the family procedurals make it clear the court's wide case management powers. And I underline case management powers. Because effectively what her ladyship was doing, I submit, was treating the recitals in the order that had been made in the fact-finding as case management, which can be done under the rules themselves.
I'm sorry, just so I'm clear about this, is this going back to your PowerPoint, as opposed to your PowerPoint?
Yes, PowerPoint.
Because this is the way you're squeezing this in, but surely what the fact-finding hearing was a consideration of whether the threshold was satisfied under the statute, under section 31, as opposed to the exercise of case management powers.
But as her ladyship was saying earlier in those other paragraphs, it's not written in stone, as it were. It's only part and parcel of the overall consideration. And therefore a judge is entitled to change his or her mind just because they rethink about it, or in the light of further evidence that comes out, which is more frequently the reason why one reconsiders. It often happens that one makes findings in a fact-finding, and then in the welfare stage there's evidence that comes out that throws doubt on the facts that have been found. But the fact-finding is not an order in the sense of the final order. And so one can, without actually formally varying an order, one can actually go on to make different findings. One doesn't need 4.16. And of course, what Baroness Hale is saying here is, strictly speaking, I know it's the Supreme Court, but strictly speaking, it's obiter.
Yes.
Yeah, of course.
And I don't know what argument, if any, had been addressed on the point that I make about the meaning of under these rules, because it's certainly not set out there. But what Her Ladyship does say, importantly, at paragraph 38, is clearly that power doesn't enable a free-for-all in which previous orders may be revisited at will.
Yeah. And then she points out at 41 that children cases are different.
Yep. Children case may be different, quite.
And then she says at 44 there's a distinction between an appeal and a variation for cause, and that's the principle underlying the basic rule in orders final once sealed. And then she says the point doesn't arise, and she's not going to express a view.
So that's the foundation that we find judges such as Mr. Justice Mostyn subsequently building on for the very, very broad construction of Rule 41 4.16, as if the words or any, under these rules didn't exist. Of course, the present case is very different on the facts from Rael. It's not a change of mind case or revisiting a previous decision in the light of different circumstances. It's just a, oops, I got it wrong, and I need to get it put right. It was my fault. Well, you suffer the consequences. You can still put it right. That shouldn't have been a problem. No judicial error, nothing of that sort. So what we say is that Rael was, in any event, if it was insofar as it was a variation of a previous order at all, it was nevertheless a case management type of order. So even if Rule 4.16 covers it and it doesn't come within the rules, it's nevertheless a category of case management case. So is there a more appropriate route, not in children cases because you need to get on with it, but there certainly is a more appropriate route here in all the circumstances.
Yeah.
Then we have Mr. Justice Mostyn building on that at tab 17, again in volume 1. Again, this is an obiter, as it were, decision, because the case before Mr. Justice Mostyn, the MAP against RAP, it was actually an appeal to the High Court, Mr. Justice Mostyn sitting as an appellate judge, from a consent order that had been made by a district judge.
Same district judge as in our case, I think.
Yes, it was the same judge. And Mr. Justice Mostyn was asking himself whether in the circumstances, rather than the matter going off for appeal, the order could have been set aside by a first instance tribunal on the basis of the power, brackets not duty, under Rule 4.16. And I take you to paragraph 15 to 18 in the judgment.
Yes.
It was a consent order being challenged, or there were probably good reasons to challenge it. And at paragraph 16, he draws attention to the civil procedure rule, which is in the same terms as Rule 4.16. And he acknowledges, on a literal reading of the words, that would, so it seems to me, permit this application to set aside the order or to be referred to a district judge. At paragraph 17, Mr. Castle had raised the question that I've raised here. No doubt having spoken to Mr. Nagpal in the meantime. Was the original order made under a statutory provision, under the Matrimonial Causes Act, or was it made under the rules. And his lordship says this in paragraph 17, but that argument was, to my knowledge, it having been advanced, for example, by the authors of Jackson's Matrimonial Finance and Taxation, is not one that's hitherto been put forward successfully in any civil proceedings under the corresponding rule. Well, if I suggest one looks at the corresponding rule, there isn't anything against that argument in there. What the judgments in those cases say is that it doesn't just cover case management orders or procedural orders, and I concede that, as long as the order, whether it be case management, whether it be procedural, or whether it be characterized as substantive, is an order for which the power is conferred by the rules. So Mr. Justice Mostyn, without analysing any of that, says it's not an argument that's been put forward successfully in his civil proceedings. And then, moreover, he refers to Rael that we've just looked at.
But he decides at paragraph 18 that the appeal route's mandatory, so that's all obiter.
That's right, so it's obiter anyway, but I draw attention to it because the argument has actually been raised, and that's what Mr. Justice Mostyn said about it, seemingly in reliance on the comments of Baroness Hale in that very different situation, which was itself obiter. Then we have Sir James Mumby in S&S. I'm confining myself really to the authorities now that were referred to by Her Honour Judge Evans Gordon in this case. While I'm talking about Her Honour Judge Evans Gordon, you'll have seen that she'd, as it were, constituted herself as sitting not in the family court, but sitting in the High Court, properly constituted herself as sitting in the High Court for the reasons she set out in paragraph 1 of her judgment. Notwithstanding that, the consequential order that was made is a mess. Quite frankly, it's as much of a mess as the...
I mean, the whole thing's a mess, isn't it?
Yeah. Yep. The authorities bundle them mess.
No, I wasn't
the procedural mess,
and the poor
that order.
And Mr. Turner, I really don't think it's fair, given the difficulties everyone's finding in the current climate, putting together authorities bundles and everything.
I mean, I sympathise
I certainly
with authorities bundle.
For myself, start criticising the poor souls that tried to do it.
It's just something that I'm personally really pernickety about, because the rules are there for a reason.
Well, I think we're keeping our pernickety feelings at bay in the light of the difficulties people are suffering.
But your Lordship's probably seen that not only is the order, which is at B1, headed in the family court, it's headed as being under Schedule 1 of the Children Act, which of course there were proceedings under Schedule 1 of the Children Act, but of course they had to be discontinued when it turned out the children weren't children in the sense they were adults.
Just, we have got at the back of the
B1 is the...
No, I've got the order. I haven't got in the front of my mind the date of discontinuance of the Schedule 1 proceedings. I think maybe in the chronology in the...
Sorry, what's the lady looking for?
I'm looking for the date that the Schedule 1 proceedings were discontinued.
That was after, it's in the chronology.
I'm just turning to chronology now.
Yeah, but the children had been adults or over the age of 18 for some time.
I understood, but...
It's the, my lady, it's the 16th of March 2018, order by His Honour Judge Everall QC giving the applicant leave to withdraw Schedule 1 and listing a cost here.
I have. Thank you very much.
And then we've even got Her Honour Judge Evan Gordon's paragraph 6, extension of time for filing the appellant's notice. It's extended pursuant to FPR rules rather than the CPR Part 52 rules, which is again wrong, but I'm not going to suggest the appeal was out of time for that basis, because that's been a slip. But what I think about, I didn't take the court to the order that was made by District Judge Aitkens. It's been sent to the court separately because for some reason it wasn't in the original bundle. Yeah. Can I just look at one aspect of the order of that? Of course, it recites that it's made under the Brussels II revised regulation, It's an order for registration, not an order for declaration of enforceability. But paragraph 2 of the order is important, and this is the order that said is engaged by 4.1 bracket 6. The judgment of the 16th November in the Paris Regional Court has been registered under Article 28.2. So there's the power, Article 28.2 of the Council regulation. So that simply confirms what I think of it, my point as to where is the power to be found upon which the order was based.
Right, all right. Now you wanted us to look at S&S, which we've
Yes,
got
please.
in
That's
Volume 2 of the Authorities, tab 30.
yes, indeed.
And what's the proposition for which you are citing it?
This is the a case about, it's one of the many cases about alleged non-disclosure.
What is the proposition for which you are citing?
The only route. Mr. Justice Sir James Mumby in that. Sorry, may I just turn it up?
Mr. Turner, you are citing this case to establish some proposition.
Yes.
What is it that you are seeking to establish by citing this case?
Well, reliance is, what his lordship does is sets out...
No, don't tell me what his lordship does. What is the proposition for which you are citing this case?
It's the construction, the proper construction of Rule 4.16.
Right,
As his
and
lordship
what do you
seems
say,
to...
what do you say it shows?
His lordship seems to suggest that it can be engaged, and of course this is a first instance decision, his lordship was saying first instance, in cases where there is an application to set aside, not rectify, but to set aside a financial ancillary relief order.
Right.
And his lordship acknowledges, as the Supreme Court was to acknowledge later in the Charland and Gohill authorities, that there is power in any event to rehear those matters at first instance.
So why does this help us when Charland follows this, when Charland from the Supreme Court is a later judgment? And this is first instance.
It refers to Tibbles at 26, and it refers to what Lord Justice Ricks had said in a case about the Tibbles criteria. And it refers there, and it's useful in this sense because it refers to the distinction between jurisdiction and discretion in the operation of the CPR rule in that case. It's paragraph 26.
Yeah.
And what's important there is the inhibition on having two bites at the cherry.
Yes.
Which I say is exactly what the wife is trying to do here. She can have two bites at the cherry, but she has to do it at the expense of having thrown away costs in the meantime. If that opportunity is now passed, well, again, that's...
Well, potentially there's the Hague Convention.
Yes.
2007 Hague.
Yes. I mean, I'm not going to go into whether there is a way in which she could do it now, because it's not for me to advise her. But she can't do it under the maintenance regulation anymore.
No, of course not.
So... I refer to what was said in those ways, and my Lord Sir Nicholas gets a mention at 26.3.
Yes.
Yep. And at paragraph 38, Sir James refers to the continuing lack of clarity at that time about how one could set about dealing with a setting aside for non-disclosure. But there's nothing in this authority, I say, that says in terms that section 4.16 extends beyond making variations of orders made under a power conferred by the rules.
Yeah. Right.
So if that's cited as authority, and it highlights that whatever the ambit of the power is, it is not unbounded. And that's important when we come to the question of, well, even if it could have been brought within the rule in the sense that it's not limited to varying orders that were made under the rule, it still has boundaries, and this far exceeds those boundaries, whatever they may be.
I thought that was what we were on, but obviously...
Yes, we are, my lord.
Right.
Gohill in the Supreme Court, tab 14.
What is the proposition for which you're citing this?
It's the fact that one doesn't need 4.16 and that there are other ways of dealing with...
Non-disclosure.
With non-disclosure.
All right,
Yep.
fine. Do we need to...
And
look at
Sharland, much the same. Although Baroness Hale refers to paragraph 4.16 in that context, and she makes again the comment that that rule is not unbounded.
Right. Well, if they don't need 4.16 to set aside for non-disclosure,
Yep.
then it's not going to help us on the bounds of 4.16, is it?
In the court below, in this case, Her Honour Judge Evans Gordon placed enormous weight on what was said in Wilmot and Morn,
Right.
tab 35.
Mr. Turner, just before you move on to Wilmot, through your highlighting of the Sir James Mumby's case and Gohill, is it your proposition or submission that when any court is faced with an application under Rule 4.16, first of all, they've got to consider jurisdiction? You've dealt with that.
Sorry, Melina.
First of all, they've got to consider whether there's jurisdiction. And then, as you said, they've then got to look at discretion. Do you submit that before a court should consider using this rule at all, they should first consider if there's an alternative route?
If there is a convenient and appropriate alternative route.
So, in other words, going down my mental checklist, is it your submission that the first thing any court should do, a bit like in judicial review, have they exhausted their remedies? Are you saying the first thing that any court has to do, or any party has to do, is consider whether there is an alternate route that could put right the problem?
Yes.
Well, if you're saying that, how does that fit in with the potential appeal?
Because there are, I did qualify it a little when relationships asked me if that was my proposition, and I said a convenient and appropriate alternative route, because in certain cases, such as Ray L, it's not a convenient or alternative appropriate route. I say that one doesn't need it anyway, 4.16, but an appeal isn't an alternative appropriate route because you need to get on with sorting things out in the child's best interest, so you can do that.
So you wouldn't go quite that far as to say you have to, whatever it is, if what you'd say is proper consideration ought to be given, whether the more appropriate course would be by a different route that didn't involve the use of Rule 4.1.
And in the matrimonial finance non-disclosure cases, well, of course, if there's got to be a, as it were, a fact-finding about whether there's been material non-disclosure, it's best for a first instance judge to deal with that. But it can be done by other routes. And so the Supreme Court in Gohill and Shun didn't have to decide whether 4.16 is engaged, because on any view of things it can be done. And certainly in the family court, there's a specific rule now deals with it. Curiously, that specific rule doesn't cover the High Court, but matrimonial finance orders are generally made in the family court these days.
All right. Thank you. So you were moving on to Wilmot then, 34.
Wilmot and Morn, her lady.
35?
Yes, tab 35. A lot of weight was placed on that. I mean, it's a case that's extremely difficult to follow, no doubt because of the input of a litigant in person who'd been trying to make troubles throughout the long proceedings.
Can you just take us first of all to the paragraph number in the judgment where...
Lady, the most important part, I suppose, is really paragraph... Well, the first point is, it's a case all about the rules, because it was a case about service and the propriety of orders for service. And the husband in that case was trying to say that since service had been invalid, then everything that followed from that was itself invalid. And the question of Rule 4.16 somehow arose in relation to that, because Mr. Justice Mostyn was apparently prepared to treat it without detailed examination as being engaged. And we can find that, I think it's paragraph 87 of the appeal judgment. But the fact is that in that case, the order that was actually in question was an order that had been made pursuant to the rules about service in Family Procedure Rule 6. And you see what Lord Justice Moylan says at paragraph 87 on page 646. For the purposes of this judgment, I'll assume that the judge was right to decide he had the power to vary or revoke, not rectify again, but both procedural and substantive order made in these proceedings.
And this is all obiter as well, as we see from paragraph 83.
Yes.
Because there was no argument on it.
Yes.
But can I just ask you this, Mr. Turner? I'm trying to make a note of what you say are the limitations on this power. You've made your point already that it's limited in its scope to orders made under the rules.
Whether they be procedural or substantive.
Yeah, well, we don't need to go back to that, but that's one limitation. But I mean, just skipping through these cases. Secondly, there seems to be a suggestion in this case and in others that the application has to be made promptly. But more to the point, the circumstances in which the court will exercise its power. I'm looking now at paragraph 59 of Lord Justice Moylan's judgment. The argument, or one of the arguments before the court bill, was that the 3.17 criteria should apply, which are encapsulated in that short quotation from Lord Justice Ricks's judgment in Tibbles. Now, I mean, are you saying, right, well, those are other restrictions which should be read into the family procedure rules as well, in the same way as they are for the CPR?
I can't say that they are restrictions as such, because there's no statute or rule setting them out.
The way the circumstances in which the court has said,
yes,
at least in the CPR context, that would normally have to be present for the court to exercise the power to vary or revoke its own order, as opposed to leaving the parties to appeal it.
Yes. Lord, so even if Rule 4.16 or its CPR equivalent is engaged in the sense that the order is one which is susceptible to it, and that raises my first question, is the order even susceptible to it? Yeah. But if the order is susceptible to it, and if you leave aside my construction, any order is susceptible to the variation or revocation. If an order is susceptible to it, there are nevertheless boundaries. It is not an unbounded jurisdiction, but where the boundaries lie is case sensitive. I think
there are really three steps here, aren't there? First question is the order potentially within the reach of 4.16?
Yes.
You say here, no, it's not, because it wasn't made under the FPR, it was made under regulation. Second question, if the order is susceptible to 4.16, what are the circumstances in which the power should be exercised? Those are what we call the Tibbles criteria.
Yes.
More or less. Maybe they don't quite apply to the FBR, maybe they do. Third question, if you do exercise the power, because the Tibbles criteria are satisfied, does the power enable you to to substitute for an order order A made under regime A, with order B made under regime B with retrospective effect. So those are the three stages.
They are indeed.
So you say, first of all, the order wasn't susceptible to 4.16. Secondly, you say the Tibbles criteria weren't satisfied. And thirdly, you say, even if all that's right, then the order the judge was invited to make goes far beyond anything that 4.16 could possibly have envisaged.
My Lord, that's it in a large nutshell. I probably need to add nothing more to that analysis because it reflects exactly what my case is. But in terms of the Tibbles...
Could I just insert a sort of sub-paragraph into one of those, which is that you'd say, in any event, what is sought, before you get to that, before we get to Tibbles, it also wouldn't be susceptible because it's not an application to either vary or revoke.
That's right, and it can't be characterised as...
So A, you say it's not under the rules, B, it's not to vary to revoke, but then we go on to, but if it is all of the above, then it's Tibbles, then it's...
Yeah, and you've got the further point that even if you can vary the order, you can't vary the underlying application.
Exactly.
Yeah.
And in terms of, if I call the Tibbles criteria, which are not written in stone and which will have to be applied in the facts of a particular case, there may be other factors which are relevant. And if and insofar as it might otherwise be engage Rule 4.16 here, the scale of the errors takes it far outside if the jurisdiction is unbounded. And that's a matter that the district judge, the judge below, Judge Evans Gordon, didn't refer to.
Yeah.
And I say that that is a factor that she ought to have taken into account in deciding whether 4.16 was engaged, not just whether it could have been engaged, but whether it was engaged. All she decided was whether it could have been engaged, and then whether it was engaged, she looked at various matters such as delay, and she seemed to think, and again, I say it's rather unfair, seemed to think that the husband is at fault himself there. There's no obligation on someone to, unless you're relying on estoppel, and estoppel was specifically disavowed, as the judge records in her order. There's no obligation on you to notice or to flag up an error in jurisdiction.
Well, you may be right about that, but don't parties have an obligation to help the court achieve the overriding objective?
They do have an obligation to, and as soon as Miss Dunseith came into the case and noted it, she flagged it up.
Yeah.
I think it was in March 2020.
Yeah. All right, now, are there any other authorities that are directly relevant to this part of the case? I don't mean analogies.
Well, the only other case, and I needn't take you to it, but it can be looked at if it needs to be. It's another long one, I'm afraid, and that's Mr. Justice MacDonald in tab 24.
That's the discharge of the returnal.
That's the question of the mother had taken the children to America on holiday. She hadn't returned them. Mr. Justice Francis had made an order for their return, and she applied to set aside that order for return when there was an appeal pending. Despite the erudite analysis of the judge in that case, including the authorities on section 4.16, it had a simple answer, as I've said earlier. It was a case which engaged the welfare principles under the inherent jurisdiction. If there had been a change in circumstances, the court clearly had substantive jurisdiction to vary any interim orders that had been made. In the event, His Lordship didn't vary or revoke the original order, but he didn't need 4.16 to be able to do that. So it was, in my submission, an unnecessary excursion. Right. The more relevant authorities were the ones about the Hague Convention, where it had been relied upon for a time, 4.16, but that's now been overtaken by the specific rule 12.52a. So I think that there are no others other than, I say, my Lord's case, which you find it referred to by, for example, Mr. Justice MacDonald refers to my Lord Sir Nicholas's case as if it's authority for the proposition that one can go outside the confines of the rules for the power of that. But that's not what Sir Nicholas was saying at all. Nicholas was saying that it doesn't matter whether it might be characterized as a substantive order or a procedural order. It may or may not come within the CPR rule. The order in front of him did, but his lordship declined to interfere with it on the facts in any event. But it's not authority for the proposition that one can set aside, can vary or revoke orders that are not made under the rules.
All right, well, we've got that point.
So, Lord, I think that's probably all I have to say about this, except finally, this is an application for permission to cross-appeal, and I would submit that if the mother was, if the wife was to succeed on her appeal, this is actually a cross-appeal because it's an appeal against a substantive decision.
No,
that the judge
don't myself see it that way. You're not appealing against the order,
well,
which dismissed the wife's application.
I'm appealing against the judgment, and the words are judgment or order, I think, if you look. And there is one doesn't appeal reasons, and there's clearly a distinction between appealing reasons and appealing a substantive decision. But it was, I would submit, a substantive decision that the judge made that Rule 4.16 was engaged, and she would have rectified the order accordingly, it would appear, save for the failure to satisfy the conditions precedent.
So you ask for
whatever your lordship,
permission to appeal if needed.
Yeah, I seek permission to appeal if needed, and even if the court finds against me ultimately, of course, having had permission to appeal on the point gives an opportunity to take it elsewhere if needed.
Yes.
Because this is a troublesome
Yes.
little point that, as you see, those are just a snapshot of some of the authorities that have been dealt with. But I do say there is no authority that binds this court to say that there is a more general power under either the CPR rule or the FPR rule that enables the court to vary or revoke orders where the substantive power to make the original order was not a power within the rules.
All right, we have that point.
Yep.
Thank you very
Well,
much.
those are my submissions on that
Thank you.
anterior point.
Thank you. Yes, Miss Bailey-Harris.
Thank you, my lady, my lord. I have discussed the scope of the anterior.
You'll take your mask off, it'll be easier to hear you.
I beg your pardon. I had discussed the anterior point and the scope of it with Mr. Turner yesterday, i.e. his essentially his appeal, and we did raise the point that he doesn't need permission because it's actually not an appeal against an order on the legal authorities, but there we are. And as we submit, the anterior question is, as a matter of law, is there power to rectify the registration order of the 28th of September 2017 under Rule 4.16? And we submit that that is subdivided into two questions. Firstly, does the power exist at all in the circumstances of this case? And secondly, if it does exist, what is its scope? What is its ambit? And is it capable of being exercised in the circumstances of this case?
Now, you've used the word rectify. Do you attach particular significance to that word as opposed to vary or revoke?
Not particularly, because in the cases which were cited below, the cases concerning divorce decrees and financial remedies, the question, there is no reference to the special rectification power, which Mr. Turner relies upon, as referred to.
Well, the reason I asked, though, and it's maybe a false analogy, if you were to vary a contract, then the variation would take effect from the date of the variation.
Yes.
If you were to rectify a contract, you would do so because the contract failed to express the true bargain between the parties, and the verbal rearrangement, let's call it that, would have retrospective effect because that's what the parties actually agreed at the time when they made their contract. So in ordinary legal parlance, there is a difference between a variation and rectification. The rule does not use the word rectification, which is why I'm asking you whether you attach particular significance to it.
I do not, my lord.
You do not.
I don't believe that significance is attached to that in the authorities in which rectification has been carried out.
Right.
The first of the sub-questions is defined in our submission like this. Is the power to rectify under 4.16 confined to rectification of an order which is made pursuant to a power conferred by the rules themselves, and it does not extend to rectification of an order made under substantive legislation, including EU regulations or the inherent jurisdiction? In terms of the, so that's the question, whether this power exists in the circumstances of this case. And Mr. Turner puts great store on the wording of 4.16 and the use of the words under these rules in 4.16. Our simple submission is that the wording of 4.16 simply doesn't bear that construction, that the insertion of the rules, of the words under these rules, simply does not confine the power to an order only made under the rules. Such a construction would so dramatically limit the scope of the power and the CPR equivalent, and would have really far-reaching consequences in both family law and civil law generally. And we do not know of any occasion on which that very narrow construction has been advanced. We simply put our hands up. We do not know of any authority suggesting that very drastic limitation. And
So, I mean, but essentially you say that under these rules does not limit the scope of 4.16 to cases where the express power to make the order is conferred by a rule rather than by
indeed,
legislation
indeed,
or the inherent jurisdiction.
Indeed, and we say that...
And that would be consistent with the case that Mr. Turner referred to that my Lord decided,
Yes.
Because the power to grant an injunction ultimately derives from the Senior Courts Act.
Yes, yes. And we would say that, as we've said in our skeleton argument, that the cases which have been cited make no suggestion that the power is confined to rectification of an order made under the rules, but extends to the power to rectify an order made under substantive legislation. In the divorce cases, which the divorce decree rectification cases, which were cited at first instance, I don't need to take you to them, my lady, my lords. M and P and X and Y, they were rectification of divorce decrees, and in our submission, what is essentially being rectified there stems from the Matrimonial Causes Act. Similarly, with MAP and RAP, which Mr. Turner refers to, the orders, such an order is made in financial remedy proceedings, which also derives from the MCA. And N and J, Mr. Justice MacDonald's decision, is simply made under the inherent jurisdiction. So we say that the literal construction of 4.16 doesn't bear the interpretation advanced by Mr. Turner. Looking at this from a practical point of view, the construction would so drastically limit the power, and we can't find any suggestion of that. And that the cases which you have in the bundle have no suggestion of that. And we say that the question of rectification in those cases is in relation to orders made under substantive legislation. We say that we don't agree with Mr. Turner's drastic limitation, but we say also that in any event, the registration order made by District Judge Aitkens was contrary to Mr. Turner's contention, made under the family procedure rules, and Part 31. And if we look at the order of Lord Justice Moylan, which is at B35 in the card bundle, it's at it's at B50 if anyone is using the electronic bundle. At B35, when adjourning Mr. Turner's permission application, Lord Justice Moylan said, in the reasons...
Yeah, no, we've read that.
Yeah. And we agree with Lord Justice Moylan on that. And if more argument is required on that, we have set out our argument that we accept that EU regulations, of course, had direct effect, but we submit that there is a role for national legislation in the procedural implementation of a regulation, provided, of course, as a matter of good EU law, that there's no substantive inconsistency with the objectives and the provisions of the regulation. So we say that it is not that the order is actually made under the rules because national legislation plays a role in implementing the regulation of direct effect. And we've cited various authorities for that. I can probably take you to them just very, very quickly. I'll just mention them.
Just show us your best one. Show us your best one.
The best one. I will show you a couple. If you would have a look, I'd be grateful at Sanders and Verhagen, which is at tab 31, and that is at page 579.
And what's this going to show?
That is a case where the CJEU had to consider whether domestic legislation in Germany, creating essentially a centralised court for maintenance claims, was valid within the regulation. So what the CJEU is looking at in that case is the nature of the German implementing legislation to see whether it's consistent with the regulation. It's not saying, oh, but you don't need any national legislation. That's essentially what that case is about. The case of MS and PS, which is at tab 22, I will just summarise that briefly for my lady, my lords. That is at page 464. That was the case which was referred to the CJEU by Mrs. Justice Roberts, and it concerned the issue of whether you had to go through the remo, basically, whether you had to go through the central authorities in order to bring an application for enforcement of a maintenance order. This concerned a non-transitional case.
Yeah.
And in this case, the CJEU looks at the implementing legislation and says basically that that if domestic legislation is wrong in requiring you to have to go through the central authorities, that's not consistent with the policy, etc., of the regulation, and says that basically the English provisions were wrong. But that's a very different thing from saying that national legislation in terms of rules plays no role. And the same point, I don't need to take the court to it, the same point is made by the Supreme Court in Pallieres, where the Supreme Court considers the implementation legislation made at national level in bringing the maintenance regulation into operation between component parts of the UK. So our point is, first of all, there is no justification for the limitation which Mr. Turner contends for, and secondly, even if there were, the registration was effected, as Lord Justice Moylan points out, under the rules. Those are our simple points on those two issues. We then move to how we define the second component of the antecedent question, which is, if the power to rectify under Rule 4.16 exists in the circumstances of this case, what is its scope, and as a matter of law, was it exercisable to rectify the order of the 28th of 2017 in the way that the judge below accepted that she was able to do. And Her Honour Evans Gordon, I didn't appear before her, my learned co-counsel did. Evans Gordon set out the width of the power and held that the power was sufficiently wide as a matter of law to permit rectification in the circumstances of this case. And
I mean, she meant by that, I think, rectification in the sense that my Lord has put to you, of meaning that restating the order with effect from the date on which the original order was made.
Yes, Her Ladyship, Evans Gordon, sitting as a judge of the High Court in this case, accepted, considered that the power was wide enough to permit what is in essence the substitution of a registration of an order under Brussels 2A and Family Procedure Rules Part 31 with a registration order under a different regime, the maintenance regulation and FPR. And Her Ladyship drew inspiration for that construction of the power, amongst other things, from the case of Rogers Hedecar.
Just before you go on to that, if, as you said, well, she obviously did, substituted one for the other, but how can you call that rectification? How does that fit into any definition of legal definition of rectification? It's substitution or replacement. It's not rectification, is it?
Her Ladyship, at paragraph 20 of the judgment, which is at page A7 of the bundle. Stated that the fact that the district judge was asked to recognise an order pursuant to Brussels 2A does not, in my judgment, deprive her of the power to recognise it under the maintenance regulation if she's satisfied of the matters necessary to confer local jurisdiction. That is in accordance with Rogers Hedecar. Now,
What power would she have had sitting in the High Court, sitting in the Principal Registry, whereas the application is supposed to be made to the Family Court? So what power would the district judge sitting in the High Court have had to register, to declare enforceable the maintenance obligations in the Paris order?
well, my lord, in what capacity was Her Honour Evans Gordon sitting?
No, the district judge.
The district judge.
The judge here is saying the fact that the district judge was asked to recognise an order under B2A does not deprive her, that is the district judge, of the power to recognise it under the maintenance regulation. But here, the application was made to the High Court. The district judge was sitting in the High Court. The order was made in the High Court.
Yes.
And, in fact, the application should have been made to the Family Court. So she would have had to do what? Transfer it to the Family Court, first of all?
Absolutely.
She could have given herself the power one way or another. Is that the way you put it?
She could have, rather than, and I think perhaps this is what Her Honour Judge Evans Gordon, why she is referring to Rogers Hedecar. I'm perfectly aware of Mr. Turner's submission that Rogers Hedecar is a very different situation, but our submission is, and my lady, Lady Justice King, would, I hope, agree with this, that Rogers Hedecar is actually cited for a much wider proposition now than in the circumstances of the original case in which Mr. Turner appeared. And Rogers Hedecar is taken as an authority for the general power of the court to satisfy itself of jurisdictional matters.
Yeah, but just to go back to my question, do you accept that the district judge sitting in the Principal Registry, considering an application made to the High Court, did not have power without doing something else?
She would have had to have done something else.
She would have taken off her district judge in the PFR.
Exactly.
Right. And what would be the procedural mechanism for doing that? She'd have to transfer the case, would she, from the High Court to the Family Court first?
Of her own motion.
Yeah.
Of her own motion.
So the steps she would have to take are she'd have to transfer the case from the High Court to the Family Court. She'd reconstitute herself as a judge of the Family Court.
Yes.
And having taken those two steps, she could have declared the maintenance obligations enforceable.
Yes.
Yes.
And it may have been considered to be, which is why my submission is that is why the learned judge below referred to Rogers Hedecar is now construed as imposing quite a positive obligation on the court to satisfy itself of matters of jurisdiction, and the process which my lord has just described in our submission would not be beyond that role.
The district judge had jurisdiction to do what she did.
She had jurisdiction to do what she did. Yes.
She did what she was asked to do.
She had jurisdiction to do what she did with the order under Brussels 2.
Yeah, which is what she was asked to do.
Yes, which is what she was asked to do.
So how does the court, I mean, if the court is going to ask itself, have I got jurisdiction to make this order, and let's assume for argument's sake the court has a positive obligation to inquire, the district judge is going to say to herself, is she not, well, they've asked me to register this order under Brussels 2. That deals with parental responsibility. I see that this order of a regional court in Paris deals with parental responsibility. I'm the right court to make the order registering it. That's what I do. There's no problem about jurisdiction. And if she was curious, she might say, well, I wonder why they haven't asked the family court to do something about the maintenance obligations, but they haven't.
Well, they did actually. If you, my lord.
Well, the form did say that the husband had not been paying the maintenance, but all it asked for was a registration of the order under Brussels 2.
Yes. But the order, the application.
Yeah.
The application of C69. If
Sorry, what page?
I think it's D, isn't
I
it?
think it's D10.
It begins at
D10?
D10.
Yeah. So this is Form 69. It's an
Yes.
application for recognition under Regulation 2201
Yes.
2003 or the Hague
Yes.
Convention.
And if
You're told that before you complete the application, you've got to read a booklet about children. Then you're told that CAFCAS are going to check it out.
Yes.
So far we're all dealing with children.
but if
It then says, list the name of the children, the types of order you're applying for, starting the earliest, so still children.
and but if my lady and my lord should look at D5.
D5.
Section 5.
Oh, yes. Why are you making the application?
We're currently within Schedule 1 of the Children Act, because at this time the Children Act proceedings were going.
And then there's a complaint that he's not paying the
Yes.
lump sum and is in arrears of
He
maintenance.
hadn't engaged with those
Yeah.
at all. And then the respondent's in breach of the French order insofar as he's not paid the lump sum and arrears of maintenance. So maintenance is referred to there.
Hmm.
And there's a decision pending in France because he's applied for a downward variation. However, he remains in breach of the original French judgment and the applicant seeks enforcement as she resides in England. So there was a...
Yeah.
And the French order is the French judgment, which is set out at page D25 onwards. It's typical of all French judgments. It's a composite consent order. It deals with the divorce itself, matters of parental responsibility, and financial matters, both the
Yes.
dissolution of community of property and the maintenance.
So this was it. There was a hearing.
I'm sorry, my lady.
Was there a hearing in front of District Judge Aitkens?
I think not. I was not involved in the case at that stage.
No,
thought
they
I-
dealt with us paperwork.
It was dealt with on paper. It was dealt with on paper
Yeah.
as his
And so
applications are.
paragraph 4 about the application, we're seeking registration of a judgment made.
Yes.
So your point is that the district judge presented with a properly formulated, compliant application for registration of parental responsibility should have gone back to the parties and said, no, this isn't what you want.
Yes. We did.
Despite the fact, of course, she may have wanted the parental responsibility order also if there were other proceedings going on relative to the children, which there clearly were.
We in our permission application, which we made last year, we did include a ground which was effectively a lost opportunity ground, which was not allowed by Lord Justice Newey.
No.
But we say.
Well, that's why I meant raise it, because you can't argue that now.
I know I can't argue that now. I'm absolutely, I'm sure of that. But we say that in the context of this case, the particular context of this case, a very purposive construction of the scope of the rule has to be adopted. We say, by way of background, that it's necessary to look at context and nature of the particular transaction for which rectification is sought. And here, we of course accept the arguments that effectively wholesale substitution and something completely different is being asked for.
Accept that.
But, and we are jumping from one regulation to another, and from one part of the FPR to another. But what is the nature of the transaction for which rectification is sought? It's not like a complete financial order which imposes either a change of status or a monetary obligation on a person. Registration of orders under Brussels 2A and the maintenance regulation are essentially gateway provisions, very different in nature from substantive orders, and we submit that it is too easy to become preoccupied with the drastic nature of that without seeing that the drastic nature is essentially seeking substitution of one gateway provision for another. These registration provisions merely open the door to enforcement, whether of parental responsibility orders or financial orders. And we say that construction, that depreciation of the nature of what you're trying to substitute is important because, okay, it's drastic, but it's not a drastic final order. It's merely letting you have access to enforcement provisions. And we say that is important. And as to the general scope of the power, to summarise what we set out in our skeleton argument, which I won't take the court's time by reading out, we say that Rule 4.16, that Mr. Turner has acknowledged, and we acknowledge, that there is really nothing in the case law which is definitive about what are the boundaries of this power. Well, we say that in the particular context of this case, first of all, Rule 4.16 should be construed widely in the light of the overriding objective of the family procedure rules, which is to deal with cases justly, and that under the overarching umbrella of the maintenance regulation, which is to promote the interests of the maintenance creditor, and that is in a context of a case notable for the husband's litigation misconduct and refusing to...
Well, that's all subsequent to the event. We've got to go back, haven't we, to what was facing the district judge in 2017, and you're absolutely right to point out there was an allegation in the form that the husband had failed to comply with his maintenance obligations.
Yes.
But the subsequent litigation misconduct, as you call it, can't have any bearing, can it?
Well, Lord, save for the fact that at the time of the registration in September 2017, there had been Schedule 1 proceedings on foot, and it cannot be an issue that the husband declined to engage with those proceedings and provide any disclosure, and as we have set out with the order of District Judge Everall, which is in the supplementary bundle.
But maybe that I've got this wrong, but my understanding was that the wife ultimately withdrew those proceedings and there was an order for costs against her.
Yes. Yes.
How can you pray that in aid then this juncture?
Well, but what happened in those proceedings, and I only came into them quite at a late stage. What happened in those proceedings is that the husband refused to engage or to provide any disclosure or attend, despite penal notices attached in the orders. There can't be any dispute about that. He engaged.
But Lord Maloney, it wasn't before District Judge Aitkens, whatever the reality of that may have been, whether it preceded or postdated, there was only limited information before District Judge Aitkens.
But that was the situation with which the wife was faced at the time of the registration.
Yeah.
There had been no disclosure.
Well, one completely understands why she wanted her maintenance order registering, but the fact is, she didn't ask. Those representing her, didn't ask for it to be registered. They asked for Brussels II parental responsibility to be registered, and that's what happened.
Yes. But I am submitting on behalf of the wife that in the particular context of this case, where one is looking at essentially substituting one gateway provision for another, that a broad construction of the FPR should, in my submission, lead to the conclusion that that was possible, as Her Honour Evans Gordon found.
Yeah.
That is my submission. Looking at the overarching policy of dealing with cases justly, and you're only talking about getting into a gateway provision, and the purpose of the family procedure rules is also underscored by Section 75(5) of the Courts Act 2003, which is in tab 40 at page 792.
Yes.
Which says in subsection 5, any power to make family procedure rules is to be exercised with a view to securing that the family justice system is accessible, fair and efficient, and the rules are both simple and simply expressed. And we say that the objective of making the family justice system accessible, fair and efficient should extend to the power to substitute one gateway provision with another in the context of this case. We also argue in our skeleton argument, as the court will have seen, that although we are asking for a leap from one regulation to another, we submit that it is wrong to see the two regulations as completely dissociated. Both Brussels II-A and the maintenance regulation provide for private international law rules under the overriding objective of the European Union to ensure proper judicial cooperation so as to promote the area of peace, security, etc. in the context of mobility. So again, we submit that the jump between regulations is not so enormous.
But Ms. Bailey, I haven't actually conducted the archaeology, which I have to do at first instance in videos to remind myself exactly how it all worked. But is my recollection not that a deliberate decision was made to extract maintenance from what had previously been one single regulation? And so for you to say, well, just ignore that really because they're all part of the same package, don't we have to just bear in mind that a decision had been made to strip out maintenance and place it in a different regulation? which resulted in the 2009 maintenance regulation.
My lady,
Or am I wrong about that?
I would submit that's a slightly different point. Family maintenance obligations were contained within Brussels 1, and Brussels 1, as justices of the Supreme Court point out in Villiers, also had a pro-maintenance creditor policy because...
I understand about that policy. My point is you're
Yes.
making the high-level submission about
Yes,
the overarching...
I am.
And I understand that, and you're perfectly entitled to make that. But all I'm saying is, do we not have to look at that against the backdrop of what actually happened in the progress of these various regulations, which resulted in a decision being made that maintenance should be stripped out and have its own regulation?
My lady, with the greatest of respect, I would submit the contrary.
Okay.
I would submit the contrary. I would submit that the creation of the maintenance regulation, which is all about family relationships, was a deliberate decision to treat family law separately from civil justice under Brussels 1. And therefore, the maintenance regulation is more closely allied to Brussels 2, which is about divorce and parental responsibility, because it's not lost in the general civil law provisions in my submission. And this is one is straying into politics, which I'm not qualified to pronounce upon, but our submission is that making a separate regulation dealing with family maintenance and not having it lost in Article 5.2 of Brussels 1 underscores that this is a proper family law regulation, and it is, as it were, the brother or sister regulation of Brussels 2, because Brussels 2 has got nothing to do with civil justice generally. So our submission is that these regulations are actually far more linked than in Mr. Turner's submission. Of course, we have to accept that family maintenance is excluded from Brussels 2, but that's a topic of one family law, private international law regulation, excluding a topic. They're both family law regulations, and so we see the creation of the maintenance regulation as a proper expression of creating two sister or brother regulations dealing with family law.
Yeah. You say it's all part of the same
I say
general
it's-
policy
we submit it's
to
all part of
encourage
the same
freedom of
thing.
movement, judicial cooperation.
Exactly.
Yeah.
And notable, as we've set out as we've mentioned in our skeleton argument, the first recitals to the two regulations are exactly identical, and there is cross-reference in Brussels 2, in maintenance regulation to Brussels 2. So our conclusion on Her Honour Evans-Gordon's construction of the power is that she was correct to take a wide ambit approach, and there's no way that we can dodge the width of what was done. We're just confronting it head on, that she was, in the light of the submissions I've made, she was entitled to move the registration from one EU regulation to another, and especially given that these are not final judgments. She said they weren't procedural judgments, but they're not final judgments in the conventional sense of you have to pay £1 million damages or you have to transfer the family home to the wife. They're gateway provisions. And we say that looking at the objective of the maintenance regulation and looking at the objective of the family procedure rules to deal with cases justly, that it was legitimate of the learned judge to think she had the power, and that there are no authorities that we can find saying you can't do that.
Well, let's assume you're right so far. What is it that gives the judge the power to make an order with retrospective effect?
The judge has the how else could she have looked at the situation? Because
Well, she could have said, all right, I've got the power to substitute order B for order A, and that's what I'm going to do. And as from today, the parties are in the same position as if order B were the one that's registered. How does she rewrite history by saying, I'm going to pretend that for the past 3 years they've been in that position?
there was an acute difficulty raised by this case because the first disclosure which the court had was the husband's Form E. There was simply nothing before.
Well, maybe. But what's the answer to my question? What is it that gives the judge the power to make an order with retrospective effect, thus rewriting 3 years' worth of history?
What else could she have done in the context of the case?
Well, what else could she have done to suit your client's case? But that's the question. No doubt your client would not be as well served if the judge had said, well, as from today, the proceedings between this husband and this wife will proceed on the basis that what is now being registered is that part of the Paris order which deals with maintenance. But that's not good enough for you. You want to go back to the beginning and say, well, you must treat these parties as though the maintenance sections of the Paris order had always been not registered but declared to be enforceable. Now, what gives the judge the power to do that?
But the judge had nothing before her other than the evidence of the Form E, because that was the only disclosure that had been given. And
no, I'm not talking about the evidence. What gave her the power? Where do I find the power in the court to make an order with retrospective effect? It's a very unusual order for a court to make. Normally, court orders take effect from the time when they are given, not from some earlier date.
But again, in our submission, you have to look at the context of the order. This is simply a gatekeeping order, and the Form E was the best she had in the circumstances of the case.
Who are you talking about when you said she had?
Her ladyship. I'm talking about Evans Gordon.
Okay.
Her Honour Judge Evans Gordon.
The judge whose judgment's under appeal. Yes.
Could I just have a moment to
Sure.
consult with my co-counsel?
Yes. There's an answer. No. There's no answer to that question.
Changing the order in future.
Yeah. We'll go out. Yeah. This perspex screen is impossible.
My learned friend has helpfully handed me some of the submissions she was in any event going to make later, and as we point out, nobody identified this error, but there's also a real world commercial reality in this case.
Yeah, we understand that. A lot of costs have been spent.
I'm sorry, my lord.
A lot of costs have been spent. We understand that.
Yes.
And it may be that they'll have to be picked up by somebody.
But the our primary submission is it is a most unusual. It is an unusual order to make a retrospective order, but we would say that there has to be a purposive construction of the power for the reasons I've said, and that purposive construction authorised the making of the retrospective order.
Right.
But
So,
I mean-
so the submission is that a purposive construction of FPR 4.16 authorises the making of an order with retrospective.
In the particular circumstances of this case.
And I mean, that was actually what this was all about, wasn't it? Because otherwise you could have gone down the less complicated route, but of simply reissuing.
Yes.
So the whole point of going down this
Yes.
rather bold route
Yes.
was to make it retrospective,
Yes.
to protect the costs,
Yes.
the orders that have been
Yes.
made.
In the particular circumstances of this case, where there is no expectation that the husband wouldn't put assets out of the reach of the wife.
Yeah.
That's the context of the case.
No, indeed, I understand that. All right. Is there anything more you want to say, Miss Bailey Harris?
I'll just consult. No, my lord.
Thank you very much. Mr. Turner, do you wish to reply?
Yes, briefly, my lord. May I first of all correct two things I may have misled the court on. The first of them is whether it is still open to the mother, the wife now, to rely on the maintenance regulation. Miss Dunzeith has an idea that because the original fringe order predated 31st December 2020, that Article 67 of the withdrawal agreement bites. I'm not sure whether that's right or not, because I know there was a special statutory instrument dealing with family law matters, which may have knocked on the head.
Yes.
But I'm not purporting to advise the wife anyway,
No.
but I simply, not to take it as read that there is no other course, whether by Lugano or maintenance regulation or whatever it is, but that's a matter for her and her advisors.
Right.
The other thing which I undoubtedly misled you on was the background to the judgment of Sir Nicholas. Can I just hand that up so you actually have it? And it's only paragraph 7 that's relevant of it.
Has Miss Bailey Harris had this?
Yes.
Yeah, I sent it last night to my
Right.
own friends. Yes.
This is, are you talking about, this is Arga Hansen?
It wasn't an injunction, as you'll see. It was effectively a judgment in default. And an order had been made under CPR 13.13.
Yes.
And it was that, as we can see from paragraph 7,
Yeah.
that my lord was being asked to reconsider. And his lordship said he couldn't reconsider that as an appellate judge because he was sitting at the same level of jurisdiction. It would engage CPR Part 3.17 because although it wasn't a procedural order, it was nevertheless, his lordship didn't say this in terms, but it was an order that had been made within the rules. You see the start of paragraph 7, the deputy judge exercised a discretion under CPR Part 13.3.
Yeah, I mean,
and it was that order.
I don't have much recollection, it's a rather long time ago, but my recollection is that I just had an application to vary the order. It was as simple as that. They wanted me to
Reopen.
look again at the
Yes.
at the issues underlying the order, and I thought that wasn't a power which I had or ought to exercise except in rather special circumstances. And the Court of Appeal on 2 or 3 occasions, I think, have said that in general that was right, but they've said, I think Lord Justice Rick said you shouldn't read this judgment, and what the Court of Appeal said in wrote as if it were a statute.
And my lord, for the avoidance of doubt, I accept entirely that your lordship would have had power under Part 3.17 if your lordship had decided it was appropriate to exercise it in the circumstances, because although it wasn't a case management order, it was an order that had been made under the rules.
But what I wasn't being asked to do was to make an order that had retrospective effect.
No.
I was just being asked to vary the order that Mr. Simon Berriott made for the future.
Yes. And let me deal briefly with my friend's points on my substantive point about the construction of the rule, under these rules. My friend says there is no authority in my favour restricting the matter. I submit that there is no binding authority the other way. And if and insofar as there is authority, it's about entirely different situations, such as child welfare. But there's no binding authority the other way to say that it must be construed so as to encompass orders which the original order was made on the basis of a jurisdiction conferred outside the rules. And that's the very point that we make in this case. There is no binding authority. It remains completely up in the air at the moment, this actual point of construction. But what we do say is that in any event, one may not need to actually decide that interesting point of construction, because even if it's right that it's capable of encompassing other situations, it cannot, we submit, encompass this sort of situation for a number of reasons. One of them is that what was sought was not variation or revocation. I mean, it can't be said that the whole-scale substitution of an order under one jurisdiction by an order under another jurisdiction to a different effect. They may both be gateway provisions, but the orders that are made are very different orders and made under a very different process. I mean, the maintenance regulation is a declaration of enforceability, not an order for registration and recognition. They may ultimately lead to an order being implemented, but they're not the same. And they're particularly not the same in a transitional case under the maintenance regulation, where there are those additional factors that the judge has to consider. So it wasn't an application to vary. It wasn't an application to revoke. It wasn't even, strictly speaking, an application to rectify. It was an application to substitute and to whole-scale rewrite, just as if, taking it to the extremes, one was saying, oh, well, substitute for this order under the Matrimonial Causes Act, this order under the landlord and tenant legislation. Of course, here they're both family law based, but that's as far as it goes, and they both relate to international instruments. But the judge didn't make a mistake here, as the courts pointed out to my own friend. The C69 form entirely relates to children. The whole form is about children, except for that one bit on D15, section 5, which in fact I don't think Judge Evans-Gordon actually saw, because if you read her judgment, she says, well, it was unclear, and I assume that it was made clear they were asking for that. Well, it's not so clear, even when you see what they were asking for, because they go on about the Schedule 1 proceedings, point out the Schedule 1 documentation wasn't with this. All that the district judge would have had would have been this application, the translation of the French order, and the Annex 2 certificate. That's all that's required on these applications. And even if she'd looked carefully at Section 5, we are currently within Schedule 1 of the Children Act, which of course itself was misconceived, and he remains in breach of the French judgment. So Schedule 1 is financial relief for children. So how does one read that? There's a decision pending in France because he applied for downward variation. So, well, if there's a decision pending in France, you can't be asking me to do anything about finances because the French court is seized of it. However, he remains in breach of the original French judgment, and the applicant seeks enforcement, as she resides in England, seeks enforcement By what route? By Schedule 1, effectively? Is that what she's seeking? Or there's no clear statement here. She makes an application for a declaration of enforceability under the maintenance regulation. It's a whole-scale substitution of a different order under a different jurisdiction, requiring a different process, and certainly in relation to a transitional case, different considerations for which the information wasn't even before the district judge anyway to enable her to have made such an order. My friend says, oh, well, you can construe broadly to ensure there's a just outcome. Well, why doesn't making a fresh application, starting again, provide an outcome that is just in the circumstances of this case where she's responsible for the situation? Why is that not just? It's perfectly simple to issue a fresh application. Of course, save that she may have had problems still with the evidential side of it. The friend says they're both gateways to similar sorts of relief. Similar, but not the same. One relates to children, the other relates to maintenance. The powers that be had deliberately separated them out. That's the point. Now my friend's asking you to reintegrate them, deliberately separate them out with separate procedures and separate forms of relief that are sought. My friend says Rogers Hedecar helps her. I submit it doesn't help her at all. Rogers Hedecar was a completely different sort of case. It was a case where a wife had applied for a divorce, and on the form for divorce, she'd ticked, as it were, one of the boxes for basis of jurisdiction. You either have to have habitual residence for X months or be a domiciliary requirements. She'd ticked a box which she couldn't actually bring herself within. The husband appealed on the basis that, well, the court didn't have jurisdiction, and it was held that, well, because she could have satisfied one of the other boxes, to get exactly the same relief within exactly the same proceedings under exactly the same legislation, it didn't matter that she ticked the wrong box. There was no question of Rule 4.16 engaged. It was a question of, well, if you look at it underneath all this, she was able to satisfy the I think it was the indent 5 of the Article 3 of Brussels 2 again. Yeah. It wasn't, as I recall it, a decision which said, in any event, that a judge must trawl through applications and look for things which have not actually been sought. But if they're actually there, then if you're seeking the same relief, because it was a divorce that was being sought within the Matrimonial Causes Act, then the jurisdiction was satisfied, even though the wife had prayed in aid the wrong basis of jurisdiction. Yeah. That's not a case which says that a court must trawl through these sort of applications where there wouldn't have been the evidence to satisfy maintenance regulation, transitional provision anyway, and say, oh, well, perhaps she meant this, even though she overtly says something different. You know, the parties are expected, their lawyers, to deal with matters properly. So in terms, I say, of dealing with cases justly, perfectly simple solution, and that is making the application again. So whether or not I'm right on my argument that the original order not having been within a jurisdiction conferred by the rules themselves, there's no power, may not be necessary to answer that, but indeed the answer to this question may be determinative of this whole appeal. Because if the judge should have found that in the particular circumstance even Rule 4.16 wasn't engaged, then that should have been the end of the case. Yes. There is a discretion, even if it does apply to a particular category of order, it's still a discretionary relief. It's not unbounded. And on these facts, the judge could have done nothing else but dismiss the application, and she failed to consider the egregious failures and the fact that she was being asked to substitute something entirely different, not rectify, not vary, not revoke.
Yeah, we've got that point.
Yep, my Lord, I think those are my submissions in reply.
Right, thank you very much. Well, we will rise and just see where we are, and we'll be back in a few minutes.
Sorry, may I just,
Yes.
my instructing solicitors...
Could you take your mask off, Miss Pallieres? Makes it easier to hear.
So, I'm so eager not to waste more time. My instructing solicitor tells me that, and my co-counsel tells me that Her Honour Evidence Gordon did have the C69 at the hearing.
All right, thank you very much.
No, she had it, but if you look at her judgment, she says I can't read a bit of it because it's illegible.
We'll be back in a few minutes, so don't go away.
Close the rise.
Sorry, I still can't hear what you're saying. Yeah, fine. Okay, I'll do it. Sorry. Sorry, I still can't hear what you're saying. Yeah. 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 Yeah, yeah. Which is disclosure, that lack of disclosure subsequent or which wasn't in front of me. Yeah. 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 If you get that far. Because if they're not
rise.
Thank you both very much for your arguments. Having heard the argument on the point raised by the respondent, we have decided to dismiss the appeal. We don't need to hear argument on the point raised by the appellant. We will give our reasons in writing, and you will get a draft in due course in the usual way. It will be your opportunity to correct any typographical errors, and we would hope that in the light of the draft judgments you will be able to agree an order disposing of the appeal. If you can't agree a form of order, please make short submissions in writing and we will make the appropriate order.
And will the court deal with costs as a matter of consequential order, or does the court want to hear about that now?
If you can't agree costs, then we will have to hear argument about it.
Right. So we'll wait to see your judgment and then we'll try to agree costs.
Yes.
And if we
And
can't,
if you
then
can't
we'll,
agree that, then you
we'll
make short
written submissions about that.
Yes.
Thank you.
Thank you both very much.
Thank you, ma'am.
Point rise.
How long will the court room stay open for my client to come and